Okay, here we go with Chapter 7, which is criminal law. And remember the difference between civil law. A civil law case is always just a case asking for money, and criminal law, where the government usually wants to put you in jail or at least wants to give you a hefty fine. So, with that difference, there are two elements of every crime. You cannot have a crime without these two elements. The first is a Latin term, actus, A-C-T-U-S, reus, R-E-U-S. You see that on your outline. That means in order to commit a crime, you have to have taken some action of some kind, even if it's just going to the pawn shop and buying the gun for the crime. Nonetheless, you have to take some action. The other element of a crime is mens, M-E-N-S, rea, R-E-A, which means that you have to have an intent, a mental intent. Let's say that someone hypnotized you so completely that you had no control over what you were doing, and they ordered you to rob a bank. In that case, if that could be true, then you would not be guilty of a crime because you're lacking the mental intent. Now, there are classifications of crimes. You have a felony, which is a serious crime like murder, burglary, armed robbery, aggravated arson, and you have misdemeanors, which are much less serious crimes, perhaps speeding, spray painting the interstate, things like that. Now, originally, legal scholars thought that corporations could not commit crimes because a corporation doesn't have any arms and legs like you and I do. Rather, it acts through people. The people could be criminals, but could the corporation be a criminal? Nowadays, of course, with crimes like antitrust crimes, corporations can in fact be criminals, and of course they can't be put in jail, but they can be given a hefty fine. Here's a list of some crimes that are especially relevant in the business context. One is larceny. Larceny is simply taking something that belongs to someone else. So if I came and I took your textbook away, that would be the crime of larceny. The more valuable the thing I took away, the more serious the crime is. If you commit larceny combined with force, then you elevate the crime to robbery. Robbery is larceny by force. So if I come and I push you down and take your money away, that's force involved, that's robbery. The next crime after that is embezzlement. Embezzlement would mean, of course, taking money that belongs to your employer. Uh, Classically, an accountant would be involved with embezzlement. Next crime, looking at my notes here, next crime hang on, is uh, burglary. Burglary is a very serious crime. If we look way back in Old English law, we see that burglary generally involved breaking into a house at night to steal things. But when that English criminal law came to the United States, the definition of burglary gradually increased to now burglary is defined as entering a residence or another building or a boat or an airplane with the intent to commit a felony therein. So if I came up to your automobile, for example, with a tire iron hidden behind my back, and you opened the door for me and I got in and hit you with the tire iron, of course that would be aggravated assault, which would have a serious penalty like 20, 25 years. But if the district attorney really wanted to punish me, he would instead accuse me of burglary, entering, in this case, a car with the intent to commit a felony therein. And that penalty may, in your state or my state, be 99 years or so. So burglary is a very serious crime. Extortion, common word for it would be blackmail. If you find out a secret about somebody and say, well, I won't let everybody know if you give me $1,000 a month, well, that would be the crime of extortion. Bribery, which usually occurs in the governmental sector, is asking money in return for some type of political shenanigans, let's say. You could commit the crime of passing a bad check. If you know that you don't have that money in your account and you write the check anyway, that's passing a bad check. Arson is another serious criminal activity. Obviously, if people could get hurt through the arson, that becomes aggravated arson, even more serious. Now, are there defenses to crimes? Absolutely. Let's talk about, well, 9 or 10 of them here. The first offense is legally called infancy. It simply means that you are a minor, under 18 years old. Now, everybody knows that if a 3-year-old punched out somebody, they're not going to be accused of a criminal offense. But what about if that minor is 17 years old or 16 years old and he didn't just punch them out, but he killed them? Well, depending on what your state's criminal laws say, and different states say different things, then in many, many, many states, for the most serious crimes, 17-year-olds or sometimes even 16 or 15-year-olds can be tried as adults in their states. Next offense would be self-defense. That's relatively obvious. We have a good fun video this time. Check your fun videos out about the Army Ranger and his self-defense. Number 3 defense is duress. So if I threaten you with immediate physical harm, like you're standing in the bank teller line and I come up behind you with a gun and I say, you give this note to the teller or I'm going to shoot you, and you give the note to the teller, you have the defense of duress. You were forced to participate in the crime. Next is mistake of fact. The best way I can demonstrate this is to give you an example. When I was a kid in the 1950s, my dad's work was next to a big parking lot, and it was an open parking lot with a little shed, and the attendant to the parking lot put the keys to the parked cars on hooks, and at 5 o'clock the attendant went home, and was a different era in the 1950s, just left the keys there, and believe it or not, nobody stole the cars. Well, one night my dad was working late, and everyone in the country seemed to own back then a 1949 dark blue Chevrolet. So my dad got the keys from the hook, got in the car, came home, and realized when he got home that he had really driven home somebody else's 1949 dark blue Chevrolet, and that person took his car home. Well, neither were guilty of a crime because that was due to mistake of fact. Entrapment is a tricky defense. It's one that's not very successful, and you have to prove that basically the government enticed you into committing the crime. The crime wasn't your idea really at all. Next offense is intoxication. Intoxication or drug use is never a defense unless it's involuntary. Try to get a jury to be convinced that you didn't commit, that you shouldn't be guilty of this crime because your intoxication or drug use was involuntary. Next offense is insanity. As the textbook points out, that is not as often used successfully as you would think. There are various definitions that the textbook talks about. The next offense is necessity. This is a strange defense. It involves when you commit a lesser crime in order to prevent a greater crime. Again, check out your textbook. Not a very often used defense. The next defense is statute of limitations. For every crime except for the most serious crimes like murder, every state has a statute of limitations, varying in length depending on the seriousness of the crime. In your state, perhaps shoplifting has a 5-year statute of limitations, where the government can't charge you with the offense after 5 years, whereas armed robbery may be a 50-year statute of limitations, where the government can't charge you after 50 years. The final defense is immunity from prosecution, where the government in order to get you to testify against, let's say, the kingpin of your organization, gives you immunity from prosecution, and therefore you cannot get charged with anything that you signed an immunity deal concerning. That's it for Chapter 7. We'll take it up next time.